Thank you, Dr. Silberman, and I will now recognize myself for some questions. You said there's some nuances in 6146 that you think should be changed, and it relates to this discretion in when to have an action arises to such that it should not be recognized here in our courts. Do you have language that you could recommend to us that you think would be definitive enough to give guidance to the courts?
Well, I probably ought to think a little bit about that, but something like when U.S. interests are undermined or U.S. interests are affected. I mean, we are a system that develops these issues by common law, and the conflict of law approaches recognize situations in which there are interests. I think the failure to give any kind of nuance here, something like when U.S. interests are affected, would allow judges to find those situations and avoid, with all respect, the Matusevich case, which I myself think is an inappropriate use of the public policy exception. We may probably differ in this group, but that is my view, and I think the interests there of England, however much we disagree with them, are appropriate.
You mentioned the other bills that have been introduced on the subject, and do you know of any precedents for a cause of action in American law being created by something happening in a foreign jurisdiction in law?
Well, I don't know of a bill that has moved that way. Certainly, things can happen in a foreign country that affect persons in the United States, and depending upon what those persons have done. I mean, but
I don't mean by what people have done, but as much as a foreign court's actions. Have the actions in a foreign court ever been such that they've been the cause for action in the United States in a court system as response?
Well, of course, we know the Yahoo case in which the court ultimately dismisses that case. That's a case for a declaration declaration of non-recognition in precisely this situation, a declaration of non-enforcement because of the judgment rendered by the French court against Yahoo. And I have to confess that I had some consultations with Yahoo in that situation, and indeed I had suggested that an appropriate course might be a declaration of non-enforcement, and at the time I said, but I think there is serious question about whether or not you can get jurisdiction. At the time I really did not have all of the facts, but the mere situation of bringing a suit, serving process on an American defendant is generally not thought to be a sufficient basis of jurisdiction. In the Yahoo case, we have a split decision in which the judges of the Ninth Circuit on rehearing, majority of the judges thought that that would be enough, but a combination of judges who thought it would not be enough and concerns about rightness, that is, that the threat was not immediate, there was no suggestion that they were going to try and enforce the judgment, led to the dismissal of the case. I mean, it's unfortunate, I think, that that case did not get to the Supreme Court of the United States, and if it did, we might have some guidance on that subject.
And you mentioned some problems with H.R. 5814 and the Senate Bill 2977, which I think are identical. The problem I take from your testimony is just that it causes this, it's overreaching in its response.
Well, it's twofold. One, there is a provision on jurisdiction in that bill, which I believe is unconstitutional. I think the notion that you can take jurisdiction merely because someone has sued in a foreign court and there has been that same speech has been disseminated somewhere in the United States, I don't think is enough to get jurisdiction over that party who brought suit. Used the foreign courts to bring suit, assuming that there was also speech in that country. They haven't done anything necessarily in the United States, at least as our present jurisdictional principles state. The second thing I worry a great deal about is the notion of a clawback statute and treble damages. I mean, we've seen the attempted clawbacks sort of from the other side when the English passed a clawback statute many years ago in the antitrust area. Interestingly, that clawback statute has never been used by the English, and I think because they recognize that it is an aggressive attempt at regulating things that we may do in the United States with respect to our views about antitrust, even if there are foreign defendants who act in the United States. The English don't think they should have treble damages. We do. The English passed a clawback statute, but it's never been used. And it's in our relationship with other countries, and sort of respect for our differences seems to me to be very important. It's one thing for us to say, we are not recognizing this judgment because it affronts our public policy and affects U.S. interests. Seems to me it's perfectly right for us to do that. It is quite another thing, I think, to take these broad exercises, anti-suit injunctions, treble damages, and clawback statutes. It shows no respect for a system that, although different than ours, is certainly a system that owes deference in situations where they have the strong interests.
Thank you, Professor.